What you said about your Korean background reminds me a lot of what my daughter-in-law of 45 years has said. And if I learned anything from Korean people, it's a hard work ethic and how you can make a lot out of nothing. So I congratulate you and your people.
Thank you.
I've asked a number of nominees about judicial philosophy. Some nominees aren't prepared to talk about their approach or won't admit that they have a judicial philosophy. You've been a federal judge since 2010, 11 long years, so I'm hoping you can have a productive conversation with me. When it comes to describing your judicial philosophy today, would you say that you are an originalist or a textualist, or how would you want to describe your judicial philosophy?
So I do look at the text first anytime I'm asked to interpret a statute or a constitutional provision. I do look to precedent from the Supreme Court as to what methods of interpretation they have used for that particular question. So in some instances, like in Heller, like in Crawford, the Supreme Court said, yes, you look at the original understanding, you look at original sources, and so I follow the Supreme Court precedent when they have analyzed something to see how did they analyze it, what is the method that they use, and then I try to use the exact same method every time.
You were a district judge handling Tandon versus Newsom. This was a case where two Californians wanted to hold Bible studies and prayer meetings in their home. The COVID rules in California prevented them from holding indoor gatherings, even though California made exceptions for other gatherings, like, just as an example, in-home filming. When you ruled against these plaintiffs, you wrote that they had, quote, little case law to support them, end of quote, in their argument that they were treated differently and unfairly. When the Supreme Court reviewed this case, the court reversed it. The court called it unsurprising, that's their word, that the plaintiffs were entitled to host Bible studies at home because California's COVID law, quote, contained myriad exceptions and accommodations for comparable activities, end of quote. The court concluded by saying that strict scrutiny, quote, is not watered down, it really means what it says, end of quote. So my question has to do with the standard of review. You applied Smith's rational basis review to the free exercise issues in this case. Now the Supreme Court has decided a lot of free exercise cases in the last 20 years. Can you name any Supreme Court case decided in the last 20 years where Smith controlled the outcome of the case?
I actually used both rational basis and strict scrutiny in Tandon, and I relied on the precedent of the Ninth Circuit and the Supreme Court that existed at the time. And at that time, the precedent concerned houses of worship and whether the capacity limits of the houses of worship were actually considered. And there wasn't any precedent at that time of having gatherings inside at the home. And at that time, I relied on the precedent, and the Sixth Circuit had a decision that had the same rationale that I adopted, that said, if there is a rule that doesn't call out religion, because all of the other cases to that point had called out houses of worship specifically, and this one was what I thought, I understand, that the Supreme Court disagreed, and that is the law of the land, and I understand. I do my best, but I don't always get it right. But they had said in the Sixth Circuit, and the Supreme Court did not enjoin the Sixth Circuit's decision, that if there is a neutral and generally applicable rule that applies to all schools, it does not call out religious schools, it does not call out public schools, all schools, that is a neutral and generally applicable rule that can withstand scrutiny. And so at that time that I made my decision, that was the law, and I did my best to follow it.
Okay. I think maybe you've spoken to this a little bit, but describe the standard that the Supreme Court currently applies to free exercise cases the legal and explain the legal standard in some detail.
Sure, let me do that. So I'd like to start, if it's okay, with just what the holding in Tandon is from the Supreme Court, which is the law of the land, which I will follow faithfully, fully, fairly in every future case. So actually, if I may back up a minute. So my understanding of how you analyze a free exercise case is you first look at, is this a a neutral and generally applicable rule? And you first look at the text. But even if the text is neutral, if the government, when implementing that rule, had some kind of religious animus, it can still be invalid. So that's the sort of first step on neutrality. And then the second step you go to is the generally applicable. So the Supreme Court has said if there are exemptions that require the government to sort of look into, what your basis is for trying to not be governed by this rule, that's not going to be generally applicable if you got exemptions. Then the second thing that we look at is whether it's under-inclusive and overbroad. So, for example, in the Lukumi case, there were laws that on their face looked neutral, right? They applied, but it turns out that they really were just applying to Santeria practices and disposal of dead animals that way, and weren't looking at fishing, weren't looking at carcasses from hunting. And so in Tandon, what I understand the Supreme Court has now clarified is the law of the land, which I will faithfully, fully, fairly implement in any future case before me, is they said basically four things. They said, first of all, it is not neutral or generally applicable if any secular activity is treated better than religious exercise. It does not matter whether there is a secular activity that's treated equally or worse than religious exercise. There cannot be any secular activity that is treated more favorably. So that was number one. Number two, they said when you're looking at comparability, so comparability comes in when you're looking at that under-inclusive, overbroad, that second prong of the generally applicable test. They said, look, you don't look at the reason why people gather, you look at what is the government's asserted interest in imposing this restriction. You look at the asserted government interest, not at the reasons why people are gathering. And then the third thing they said is for the narrow tailoring under the strict scrutiny analysis, you have to look at religious exercise with the same precautions that you would any secular activity. So they've explicitly said you cannot assume the worst of people when they go to worship and assume the best when they go to work. The last thing the Supreme Court decided was on the issue of mootness, that it doesn't matter whether the government modifies or withdraws a restriction. If there is the possibility that the government official would reimpose that heightened restriction at a later time, the case is not moot. And so those are the holdings of Tandon, I believe, and that's how I believe it further clarified the existing framework, the existing analytical framework. And again, that is what I will faithfully, fully, and fairly apply going forward.